Joining me yet again is Chris Geidner, author of Law Dork on Substack. Go check it out. It's a great source for all things law and Supreme Court. Chris, thank you so much for joining me. Welcome back. How are you?
Wonderful. How are you?
you know, you just gotta take the good with the bad, and there's a lot of bad.
It's true.
I feel like I often reach out to you to bring you on and to pick your brain whenever we're at a big moment at the Supreme Court, whether it's the end of the term or the court just heard a huge case that could change things seriously and drastically in our country or in our law. And we are now at that point again near the end of a term where we're expecting all of the big cases. And we just had a decision come out today about Mifepristone, the abortion pill. And I don't know if it went exactly how everyone expected. My colleagues and I certainly were very worried about this case. Could you break down what happened and why it was unanimous?
Yeah, I mean, so we had this far right challenge that in any other time would just have almost literally been laughed out of court. The premise of this challenge, the start of this challenge, the real what they wanted from this challenge was was the 2000 approval of Mifepristone to be reversed. This was 23 years later, 22 years later when they brought the lawsuit, 23 years later when it got to a point of ruling, and 24 years later when it would have been before the Supreme Court. They wanted this group of anti-abortion physicians and the association that was created conveniently to represent their interests that happened to be located in the Northern District of Texas, where they could file a case and guarantee that it would be brought before one of the most far-right Trump judges in the country, Matthew Kacsmaryk. And because of that, in the wake of Dobbs and Roe versus Wade being overturned, they managed to get a ruling last April from Judge Kacsmaryk that went along with that. That said, I will stay the effective date of the approval, which essentially was removing the approval. He also, it wasn't really as close attention paid to it at the time back in last April. He said, I also find the same way about sort of these later moves by the FDA to ease restrictions on Mifepristone in 2016 and 2021. This took a case that a few of us had been talking about and just made it front page news. It very quickly, because of when it was going to go into effect and that it was going to have nationwide effect, went up to the Fifth Circuit. Even the Fifth Circuit, that crazy bastion of where no precedent matters, the dark zone, even they said Kacsmaryk's ruling about 2000 went too far, and they put that on hold. They would have allowed the 2016, basically the 2016 and 2021 easing of restrictions to be pulled back. That, however, quickly on a stay application on the shadow docket, it was one of the rare times where the shadow docket worked in the left's favor, went up to the Supreme Court very quickly. And before the end of April, the Supreme Court said, no, while this case is going on, Mifepristone stays available on current terms. Now, that was a real harbinger of things to come. Like that is now technically, that means that the court said that the Justice Department had a likelihood of succeeding on their arguments. And so that sort of told us the Supreme Court was skeptical of this challenge. It continued through appeals at the Fifth Circuit. They, on the merits, reached the same conclusion. They said, we think the 2000 challenge is untimely, but we agree with you on the 2016 and 2021 challenge. Importantly, they also found that these anti-abortion doctors and associations had standing to bring the lawsuit. That we all said was absurd. But here's the thing. This is the dirty secret in the law. Standing is made up. And if you want to find standing, you do. If you don't, you don't. Now, under precedent, these folks didn't have standing. They are so far removed. These are people who do not prescribe mifepristone. They don't have patients who take mifepristone. They do not, or none of them, even in their declarations, said that they had ever been forced to, like, one of their like claims was like, because mifepristone often can lead to people later needing to come into hospitals and get follow-up treatment, and including sometimes needing to get an abortion if the mifepristone doesn't fully work. And so they claimed like this, the increased use of mifepristone, these reduced standards for when it is used, will lead us to us needing to treat these patients. But in their declarations, none of them said they had ever had to do that. But that was fine for the Fifth Circuit. They said, yeah, we get it. You're worried. This put us in a weird position that the Justice Department and Denko Laboratories, which makes Mifeprex, went to the Supreme Court, went into the warm embrace of the court that had just overturned Roe versus Wade and said, we want you to take up this case because it needs to be reversed. Because otherwise, this Fifth Circuit ruling would have gone into effect. So they were sort of forced to ask the Supreme Court to take this up. And I don't remember now, we've had so many late grants this term, either in December or January, the Supreme Court said, we'll take it up. And they heard arguments, and at the arguments, it was pretty clear, like, the majority of the court did not like this case. They did not like standing. They did not like some of the merits. It wasn't clear if there was a majority that didn't like the merits, but there wasn't a lot of support for the merits. There was very little support. There was a little support from Alito at arguments on standing, that he was like, well, somebody needs to bring this. Despite the fact of how much they got out of the Fifth Circuit, the challengers, these anti-abortion association and doctors, asked the Supreme Court to hear their own appeal too. They said, we want you to hear an appeal over the 2000 approval. Like, we disagree with that one thing we lost on. And another sign of where this was going is that the Supreme Court denied cert on that. So they said, we're going to take up DOJ and Denko's appeal, but we're not going to take the anti-abortion doctors' appeal over 2000. So when it got up to the Supreme Court had already issued a stay of Kaczmarek's ruling. The Fifth Circuit had already said the 2000 went too far. The Supreme Court had already said, we're not even hearing your appeal of the 2000 approval. And so we went into arguments and we were like, this is not where Aaron Hawley wanted to be on this case. This is not where the anti-abortion folks wanted to be. It didn't go well, and we got an even stronger ruling today that was unanimous. I think there were some reasons why it was unanimous that we can talk about, but it did shut down this avenue for these sorts of challenges pretty strongly.
So the reporting that we saw was that they rejected this challenge based on standing. You talked about you can just invent it. We've seen it happen before. It's convenient, but like you say, there's precedent for them not having standing in this case, and even just laying out who they were and that they had no real connection to
Yeah,
even the
I mean,
prescription of this drug. It doesn't make sense.
Justice Kavanaugh wrote the majority opinion, and he really it was an
Feminist
aggressive. I
icon.
mean, it was this rare moment where I was like, "Yeah, get him, um, go Brett." I mean, he like, I mean, there was some snark in there. Like he was like, there was this section where I don't have the actual the opinions over in my book bag. But he like he goes through this section about basically he says like we don't have doctor standing. Like we don't like not doctor patient, not like some close relationship, but like because I'm a doctor and I disagree with this public health rule, you should give me standing. And like, I mean, in it's one of those drill tweet. You do not have to hand it to Brett Kavanaugh under any circumstances. But he was sort of like, no, 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 no. That would just ruin every doctor can sue whenever a public health rule is passed that they don't like. He talked about the fact that, I mean, there was like right from the start it was almost like what do you think you're doing? Like he was like, this is not a circumstance where these doctors have patients who are using this regulated product. These are doctors who do not want a something to be used because they do not like it, and that's not how it works. He says the plaintiffs do not prescribe or use mifepristone, and FDA is not requiring them to do or refrain from doing anything. Rather, the plaintiffs want FDA to make mifepristone more difficult for other doctors to prescribe and for pregnant women to obtain. Under Article 3, a plaintiff's desire to make a drug less available for others does not establish standing to sue. Like that's it's just there. And it's sort of
Yeah.
like deal with it. Um I will say an important, and I do think that this helped the unanimity factor. There's a large portion of the middle of his ruling where he talks about the fact that these doctors are will not be in terms of like, will they downstream have to deal with the effects? Like, might they need to treat patients who come in? That argument that we had talked about. He says, well, there's a simple reason why that's not an issue and doesn't justify standing, and that's that there are robust conscious protections, that doctors do not have to perform abortions if they do not want to, if it's against their conscience. And he pointed to the church amendments, these regulations that provide these conscious protections, and he also pointed to the fact that Solicitor General Elizabeth Prelogar, in these arguments over this case, and in the arguments over the emergency room law, EMTALA, that in both of those cases, in both of those arguments, she talked about the robust protections for individual doctors that conscious protections provide. And he basically said, like, that's kind of beginning and middle and end for the possibility of you claiming standing from that in order to have standing, you have to have causation. And he basically said that's like a brick wall in the middle of your causation chain that prevents you from claiming causation. And so that was sort of a little, it was obviously those conscious protections were something that anti-abortion forces were very much pushing, that was passed along with like the time of the Hyde Amendment and stuff like that. But in this case, those protections provided a basis that I think enabled some of the conservative justices who might have been more willing to listen to the doctor's arguments, a way to say, no, we can go along with this standing argument unanimously.
Because it was standing and wasn't necessarily on merit, if I'm getting that right. There's a
Yeah.
chance this comes back, right?
Yeah, I mean, they did not resolve the question of whether these rules were properly promulgated. Now, also, the denial of cert in a denial of cert is not a ruling on the merits. But I mean, as to the 2000 approval, you can safely say that's done. They're not going to succeed in that claim. The Supreme Court didn't even consider that worthy of cert. And so I think that argument is done. There was a group of conservative attorneys general who intervened below in this case. Kansas, Missouri, and Idaho, I think. A real trio of winners, let me tell you. It's yeah, Chris Kobach is the Kansas AG now. Andrew Bailey, who is truly one of my favorite AGs to mock. He was the director of corrections, and if you remember, like, Kansas is the state where the governor had to resign, and so you had like a musical chair of literal failing upward of white guys, and so the chief counsel of the director of corrections became the appointed governor's chief counsel, and the AG Schmidt or whatever his name is now a senator. I don't know. So then an appointed Andrew Bailey, the appointed governor's chief counsel who had been the DOC, became the appointed AG. And so this appointed AG, because the world we live in is worried about a right-wing challenge, has taken all sorts of just utter far-right, hyper-active right-wing positions. He joined this, and then Rao Labrador in Idaho, who I've done some writing about, was sort of MAGA overtaking the Idaho Republican Party. He joined it, and they're down there in Texas. This really smart lawyer, Adam Unikowski, who has a great Substack, and has been sort of obsessed with the standing issues in this case. He says that because of the fact that this was decided on standing, he had said this before today's ruling, because this was decided on standing, that means that there was never standing. That means that when Kaczmarek got this, there wasn't standing. That means that when he initially decided this last April, there wasn't standing. So that means that by time these AGs tried to intervene, there was no case for him to have considered intervention in. So he says the case is dead and it shouldn't be allowed to go on. Now, that's in a reality-based world, not in the dark space of the Fifth Circuit. So who knows? There also could be other challenges brought, raising these. I do think we need to realize that, as I said, like, standing is a nebulous thing. And it is a choice not to find standing. Now, it could have been a purely partisan, not even partisan, a purely small p politics choice that the liberals were happy about on a substantive ground, but that the conservatives went along with because they didn't want this ruling this year in an election year. That's like an ultra cynical view. But even if that's so, we're talking about it taking time before this would come back. But I do think on I'm of two minds on this, and I'm frustrated because the Supreme Court's treatment of stare decisis, the Supreme Court's treatment of ethics, leads to people having legitimate questions about, does today's decision mean anything? And so I get it. And to the extent that people who I really respect, like Dahlia Lithwick and Mark Joseph Stern, are like writing things today, like let's not give the Supreme Court any chits today. They get no credit, no gold stars, nothing. I mean, sure, they don't get gold stars. This is like the most obvious least they should do. But I also do think that there's a reality that, like, when you get a 9-0 decision like this, when like even like, yeah, Clarence Thomas wrote a concurrence, but it wasn't a concurrence saying I'm only agreeing on technical grounds, or I like am like basing my decision on something else. He was doing a Clarence Thomas concurrence. He like had like another issue that, like, I know it's not an issue today, but I think in the right case we should revisit associational standing altogether. Like that's a Clarence Thomas like writing. Like we're used to them. That but he said I join the opinion in full. So like Sam Alito, Clarence Thomas, the decision was by Kavanaugh, like Amy Coney Barrett, like everybody was on board with this. And I do think that it says something about like this was just not the approach. You can have, like, we could still see a very different ruling in the EMTALA case. Like, I'm not saying this was like some like great like choice victory, but I do think like, I mean, there's one like take the win. Um, but like second, I do think there is a substantive component to every ruling, and like, yeah, the far right can keep like pursuing this angle if they want, and I'm sure they will. But I do think that we got a sign today that was pretty solid from this court that 5 of the justices freely went forward and overturned Roe 2 years ago, saying this ain't the way. Like this is not the path to go. And I think that that matters. And I'm still sort of, I mean, as I think you can tell, sort of like working through how to talk about that, because like I get like it's totally legit to say like this decision could be overturned next week because Sam Alito has told us that stare decisis means nothing. And so it's totally legit to raise that criticism. But I also think that like both choice advocates and people who want a more stable Supreme Court, take the win and take the stable ruling from a court that says, we're not going to upturn standing precedent in order to give these doctors standing, is a good thing, and we should say that. Like, that doesn't mean that the Supreme Court is good. It doesn't. It's not a story that the conservatism of the court is overstated. But when the court does the right thing, I think we can say that, and I think we should.
So you mentioned Sam Alito, and I wanted to get your
I
thoughts
regret to
on
do
this.
so, but
Yeah, you did so begrudgingly, but you did. And Sam Alito and Clarence Thomas, especially, have been at the center of a renewed push for Supreme Court ethics. We saw the saga. We talked about it on the show about Sam Alito's wife's flag obsession and the all of the issues with that. And then, of course, we have the disclosures recently that showed Thomas has accepted over $4 million in gifts, many of them luxury vacations and jets. And then today, we learned that he didn't even disclose all of the trips.
of
There were
course he did.
at least
I mean,
at least three more that he never
of course he
disclosed.
did. I mean, of course he did. I mean, the fix the court document had to create another line for likely, because there's stuff that we know that this guy did, and it's like you go through and it's like no one, nothing, 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 18 million, like whatever. I mean, no, it's clear. I mean, Clarence Thomas does not care, and that's that.
Mhm.
And I mean, Sam Alito doesn't care, is mad about it, and both of their wives support them in that. And
Yeah.
we know that now. Like, little did we know that they both had that. We've known for so long that Ginny Thomas was there, but we had no idea that we had a literal cardboard cutout parody of a character in Martha and Alito. I mean, it's. I mean, it would be horrifying if it wasn't like I'm sorry, but it's camp. Like, it just is. We've got this crazy woman running around like her multi-million-dollar neighborhood with a lagoon in Virginia, complaining about pride flags across the street. Like, go for it. Like, I love it. Like she's literally making up flags. I mean, I love that pettiness. Like, let's go. I mean, yeah, go for it. Be a loon in your lagoon, and like but retire. Like, she's right. Just retire Sam and let her fly her freak flag. I mean, but it's offensive, it's horrible, and Sam Alito should not be sitting on the Trump case. Sam Alito should not be sitting on Fisher. Sam Alito should not be sitting on Moore versus United States, which we still have not gotten the result of. That's the wealth tax case that I did a lot of reporting on, that where the lawyer who was one of the two people who he did those Wall Street Journal interviews with is also on the brief for the Moores who are asking for this case. I mean, that's ridiculous. I mean, Thomas obviously has his conflict via Ginny's texts with Mark Meadows. I mean, yeah, no, they should not be on them. And I've also written about the fact that I think that this very strongly and negatively reflects on the Chief Justice. And I think his letter the day after Alito's this time around was appallingly weak. It was just I mean, it was it wasn't disappointingly weak because it was exactly what we expected, but it was nonetheless appallingly weak. Like the fact that he couldn't even say I think that he, I mean, he can say that Justice Alito makes his own decision, which is true. Like he's not the chief justice, like he's like the den leader. Um, but he can say, I think that blah blah blah, and whatever he wants to say about the ethics rules, and that justices need to take a hard look and assure that they are living up to the letter and spirit of our ethics rules. Um, and I pointed out at Law Dork that like the court has dealt with bigger problems than this in the past, and they found a way while not like taking away the right. I mean, there have been times when the justices have basically threatened to hold over cases if justices didn't act accordingly. And they could do that. Like if a majority of them got together and said, like, if you do not recuse from this case, like we will not decide it. We will hold it over till next term. Now, of course, in this instance, that would make us even matter because that would be like the immunity case not being decided this year. And so we don't want that either. But I mean, the justices can also speak out. Like they are not prohibited from speaking out about the ethical rules that they think should apply to the justices. If Justice Kagan went out and gave a speech about ethics and talked about the ethical rules and when justices should recuse themselves and how important she thinks that is, she wouldn't need to name Sam Alito in order to make a clear point. Like she wouldn't need to like malign by name her colleague. She could. I'd be fine with that. But like even if we want to grant that like she might not want to do that, like it should. And I mean, and obviously like Biden could do more, Durbin could do more. I think it was good that Durbin signed on to that letter with White House that did lead to those responses. And I mean that shows you like we did get a response from Sam Alito within a week. We got a response from the Chief Justice. I mean, think about the fact that, like, last time when they called Chief Justice to testify, like, it took them forever to get back. And then he was like, nah. Yeah, he said nah again. But, like, I mean, the fact that we're getting, like, responses from the justices within a week of like a letter coming out from two Democratic senators, like shows you how much this attention and criticism and reporting and speaking up from public officials and those outside of government has mattered and has changed the conversation.
Now, Sheldon Whitehouse has been on this issue for a while. He
Yeah.
used a procedural trick, I believe it's called unanimous consent, to try to force, uh, uh, well, to be redundant, an enforceable code of ethics on the Supreme Court. And of course, you had conservatives in the Senate run to the defense of these conservative justices, saying this is an effort to undermine the court, was what Lindsey Graham said. Do you think we'll ever get to a point? It certainly doesn't look like in the near future, but will we ever get to a point where Congress is okay with implementing a code of ethics for the Supreme Court? And also, is there a situation where the Supreme Court would even allow that? Because they seem to insist under the Roberts Court right now that that's not even Congress's purview.
Well, I mean, we've got this funny thing where they say it's not Congress's purview. I mean, now I will say Alito said it's not Congress's purview in one
Okay.
of those Wall Street Journal interviews. What Roberts has said, it was back in his 2011 report, end of year report, and they always just like point back to that, is that that it could raise serious questions about separation of powers and has never been adjudicated by the court. Um, at the same time, and on the contrary, the justices fill out the financial disclosure. That's a law passed by Congress. Like, so if Congress cannot pass laws that the justices have to pay attention to on those fronts, then why are they filling out the financial disclosures? Is that merely advisory? Like, are they only doing that like to be nice? Is Clarence Thomas doing these awkward admissions to be nice? I mean, I think we know the answer to that. I mean,
Yeah.
they clearly do think that's a law. Sam Alito Sam Alito asks for the extension every year and gets the 90-day extension, but he's asking for the extension because the law gives him a 90-day extension. He doesn't say, I'm going to turn it in 6 months because that's when I want to. He asks for the 90-day extension the law grants him. I mean, it is this weird thing. Like that's been there since whatever Watergate, since the disclosure laws. In 20. Oh, actually, this is really interesting. There's a new law in 2022. This little understood that's come up really important for my reporting recently. This little noted law was passed that was mainly thought of as a law that required the judicial disclosures to be placed online. For a long time, Fix the Court was where we would all get them because they would request them and they would upload them and we could get them from them. This 2022 law passed that was basically a get with the times law. And it said that the administrative office of the courts within a year had to start posting these online. And they started doing that. And it's a great website. You have to like put in your name to get it, which I don't like. It's yeah. But they claim that's just like a bot thing, blah blah blah, whatever. Fine, I'll allow it. But there was a second part of the law that's really interesting. It added the judiciary to a longstanding ethics rule that applied to the rest of, I think, both executive and congressional branches. That is a called a PTR, periodic transaction report, and it's if you make a stock say a transaction that is more than $1,000, you have to report it. You have to file this disclosure report within 45 days of the transaction posting. That had never applied to the judiciary before. And that was a part of this 2022 law. It went into place. And that is why I was able to have that Sam Alito beer stock story.
Yeah.
This story that I had, I guess it was just last month. My God, what is time? That Sam Alito, on the same day in August of 2023, right after a slew of stories about the anti-trans Bud
Dylan
Light,
Mulvaney had
Dylan
one beer can.
Mulvaney, yeah,
One beer
uh,
can.
beer boycott, that he sold his stock in Anheuser-Busch and purchased stock in Molson Coors on the same day, in August 2023.
I mean, that makes more sense with the flag stuff.
The reason I found out about this is he had to file a periodic transaction report. We still wouldn't know about that because Sam Alito took his 60-day, 90-day extension. So we're not going to be getting his financial disclosure until August. But because he had to file this periodic transaction report, it showed up on the website. I got a hold of it and was able to do a report on it. And so, like, again, this is a situation. This is in the midst of Sam Alito having just told the Wall Street Journal that Congress can't pass ethics laws. He filed a periodic transaction report that was required under an ethics law passed by Congress in 2022. So what is it, Sam?
It's oh god, it's so slimy. So you mentioned it earlier, and before we wrap up, I have to get your thoughts on the Trump immunity case. So of course, there's a big push. People don't want Alito and Thomas uh, on that case. They want them to recuse. I can't imagine that's going to happen. They
Well, it's not. I mean, Sam Alito has said it's not. And I
Yeah.
mean, Thomas participated in an argument. I mean, when justices recuse, and we've seen this with like Justice Jackson has when she recused from the Harvard affirmative action case, and she actually recused from Loper Bright, the one of the two Chevron cases, which is the reason why the court took Reckless, the other, or Relentless, the other Chevron case. I keep calling it Reckless. It's a Freudian thing. Uh, when they do that, we learn about it very early on because there will be a note like in the docket, like as soon as something is filed, that it will say like as soon as there is a court action, like even if it's like if you request a delay in the printing of the appendix, in the filing of the appendix, it will say like Justice Jackson did not participate in the consideration of this motion. And so we'll learn that very early on. And that didn't happen. And obviously, like once they participated in oral arguments, we know that they have decided to participate. And in the case of Alito, he has sent a letter to Durbin and White House saying, I am not recusing. So
Do you think there's anything that we can glean from any recent cases or any alignment in recent opinions about where the court might fall on this case? It
I
does
mean,
seem like such an absurd argument, though.
well, here's what we know. And ultimately this is all that matters for now. They have created the environment. They're not alone. There are others to blame, and we could go through that at any point. But they have created an environment where the case will not go forward almost certainly before the election. Jack Smith asked for cert before judgment, which would have leapt over the DC Circuit's consideration of the case back in December. They denied that request. When the case was taken up on cert after the DC Circuit's ruling, they held it for a while before granting cert. They granted a bit of expedited review, but they certainly didn't hear it as early as they could have. Then they heard oral arguments on the last day of the term, whereas if you remember when they took the 14th Amendment case, they actually added a day to the beginning of that month. Like, remember, we came in for one day earlier in the month before arguments. Whereas this time they added a day to the end of arguments. And now they've sat on it. I don't want to say they've sat on it, but they have not issued an opinion. They issued that complex decision about the unprecedented nature of the 14th Amendment insurrection clause treatment. They were able to issue that decision within a month. It's now been well over a month. We've now gotten the Mifepristone ruling, one of the big decisions this term. So if there was even a chance of this being the first big decision, that's gone. like I think they've already given us the tell, and that is we're not hurrying this. We're not treating this as the sort of expedited urgent case that Jack Smith urged them to treat it as. And I think that tells us more than whatever ruling they get, but we also got a lot of information at arguments that suggests that the odds are we're going to get some sort of a mixed ruling where they don't say that there is uh a writ large end of immunity the second you end the presidency, and that it's something that will need to go back to the district court at least for some final resolution of how it applies. This discussion of the outer perimeter that applies in civil cases. Um, if we get them, if they take the time and we get a mixed ruling that requires further proceedings before they're even able to go forward with the merits of the case, that could lead to another attempt at appeals. I mean, it is disheartening to say the least. But I think in terms of like what we can read, it's already been written. Like there's no tea leaves to read when like it's June 13th when we're talking.
Is there a possibility that this they could hold on to this and release their opinion later in the year, or do they have to do it by the end of the term?
I mean, this is one of those I can't give you an absolute because it is the Supreme Court. And my bottom line rule back from my BuzzFeed days with Catherine Miller was at the end of the day, the Supreme Court does what it wants as long as they have 5 votes. So like ultimately, do they need? Is there anything written down? Do they go to jail if they do not release a ruling? No. Um, unless they changed the way they handle cases, unless they did something truly unprecedented, one of two things has to happen with the case. They need to release a decision or they need to release an order setting it for re-argument in the fall. And there's nothing to set for I mean, we have no reason to believe that that is happening here. Um, they're like it would be a. I mean, you talk about like what tea leaves, what we can read in from it. If anything happens other than those two things, like it is going to be a like if you thought that the if you thought that the pieces saying like the Supreme Court's out of control thus far have been bad, like you'll see me like jumping from ledges if we get that. Like that not as in jumping off ledges, jumping up and down on ledges. uh drawing attention to,
Okay.
not jumping off ledges. I mean that would they it would be. I mean, we won't necessarily get a ruling by the end of June. They could go into July, like, but before they recess for the summer, they dispose of all cases, either by deciding them or by setting them for re-argument in the fall.
All right. Well, we will wait and see, and we will look to you and Law Dork for clarity as these decisions come out. Where can people follow you and find and subscribe to Law Dork?
Yeah, subscribe to Law Dork, www.lawdork.com. Google it, just search it. It's everywhere. And I am Chris Geidner on everything, all of the platforms. And Law Dork News is on uh, Twitter X, Instagram, and Blue Sky. I am also on Mastodon and Threads.
Oh, okay. Yeah, you got to check every single box these
Yeah,
days.
it's it's I mean, there are many things that I am mad at Elon Musk about constantly. Um, the lack of green circles, the lack of likes, among other things. But uh the fact that in order for me to like I mean, one, I just can't engage with people as easily. Like, I spend more time making sure that I share things everywhere. We were talking before we started recording about this new Title IX ruling over the Biden administration's Title IX regulations. And like, I was literally running home from dinner to talk with you. And I was like, needing to make sure like did I post it all four places like it's it's so miserable. Like I just hate it.
Yeah, it's a very terrible state of affairs. It's
Yeah.
bad.
In addition to the Nazis. Um,
Yeah, that's a given. Chris, always a pleasure.
here
Thank
we
you so
are.
much for joining me.
So good to talk to you, Jordan.